last thing you want to do is litigate a case. And I know that sounds weird for a litigator to say that, but time and money is so critical in development. If there's a way that we can move this thing forward and get the approval, it might not be everything you want, but 90% of what you want, I think it would still be a good plan.
Hey, what's going on, everybody? Welcome back to the Land Development Podcast. I'm your host, Ryan Glick. If this is your first time joining us, each week when you tune in, you'll hear one of two different types of shows. Sometimes when you tune in, you're going to hear industry news. That's where we pull up a few different headlines and we talk about what it means for the land development industry. And then other times when you tune in, you're going to hear an interview style show where we have on someone associated with the land development industry and we dig into some topics that are of interest to them. Now, today I'm excited to have with me Dan Dalton. Dan is a partner at Dalton Tomich, a law firm based out of Detroit. Dan, thanks for joining me.
Hey, it's great to be here, Ryan. Thank you for the invitation.
Yeah, absolutely. It's a topic that we haven't really talked about before, and I mean, to be quite honest, I don't even know if we probably haven't even had a lawyer on the show yet. So, yeah, a first time there. But I think where I'd like to start with our conversation is really about how you got into kind of the area that you focus. And so, from looking at your website and everything and seeing your bio, your focus is on religious land use and zoning litigation. And so I'm just curious, a lot of people specialize in certain things in the legal world. And for you, this is your specialty. How did you get into that?
Well, great question. And thanks again for the opportunity to be here. I clerked for Supreme Court, the Chief Justice of Michigan Supreme Court out of law school. After that, I went to a firm and I did zoning defense work, where the firm defended cities when they were sued for zoning denials. I did that for about 8 years. And then afterwards, I started a firm with another person. And we had a pastor that walked in the door one day, right after we started. And he went to talk to me. And he knew that I had done zoning work in the past for the city of Southfield, Michigan. And he had bought a piece of property in Southfield, bought the building. He went there to the city development office before buying it and asked if he could use it for a church. The city said, sure. And so he bought it, sold this other building, renovated the building, went to get an occupancy permit. And the city said, I'm sorry, we're not going to give you the occupancy permit. We sold all the property around you to a developer for single family residential. We want you to sell your property to the developer and go somewhere else. And he came in and told me the story, and I thought, that doesn't seem right. I represented Southfield before. I know the city attorney and the planner. Let me go out, let me talk to them and see if I can get it fixed. And quite frankly, Ryan, I thought, this will be an easy one. We'll go have lunch. I'll agree to plant some shrubs. We'll put a smaller sign, then we'll get this used. So we went out to lunch, and both of them told me, no, we can't have that church there because we have a developer coming in. And I told them about this law that was just passed in 2000 by Congress. And they said it didn't apply to the city. And I said, well, you're part of the United States, so it kind of does. And they disagreed. So we ended up in a lawsuit. And it was one of the first cases in the United States under RLUIPA, the Religious Land Use Act. So we litigated that case very hard for like 3 years. Got up to the day of trial, or the week of trial. The Detroit News, at that time, there was a Sunday Detroit newspaper, and the News did a story on a Sunday above the fold on this case. And then that hit the wire service. And all of a sudden, we got a whole bunch of calls from churches and other ministries that said, hey, that happened to us too. The case settled the next day. We just started doing, and I just started doing a lot of work in this area. Really passionate about the church and about religious ministries. We've done a lot of work with homeless ministries and food pantries and churches and schools and universities. And I started writing on this topic and speaking on it. So I just started getting a lot of work across the country in this area. And from that came the other area we do in disputes, which is where churches want to leave a denomination and keep their property. And we represent local churches and we represent denominations in those type of matters as well. So it's just literally a pastor walking into the door and, never planned on doing this work, quite frankly. It came to me and we've done very well. We really kind of hyper-focus on this and we've been very successful at it.
Well, nice. That's interesting. And so can you talk about what this act actually is, like the high level of it and like what it when it comes into play?
Sure. So RLUIPA was actually the last act that Congress unanimously passed. It was signed into law in 2000 by President Bill Clinton. And really, what it does is it puts religious assembly uses on a level playing field with other secular assembly uses. So, and this is just from a real high level. So, if you think about it, if in a zoning context, if the city allows for theaters or city halls or parks or funeral homes or any places of public assembly in a zoning district, it should allow for religious assembly as well. There shouldn't be a distinction between the two. And there's different parts of RLUIPA. There's the equal terms part, which is kind of what I just said about a match for a match. There's another part called substantial burden, where if you do something as a municipality to deny a religious assembly's uses and it substantially burdens their religious exercise, there's a claim there. There's a claim for unequal treatment. If you allow one denomination's use in one city, but you don't allow another denomination's use, there's a violation. If you completely zone out religious uses, which you really don't see that anymore, but at one time you could see zoning codes that just said, we do not allow religious uses in town. That would be a violation of the act as well. So it doesn't preempt zoning. It basically puts zoning on the same level playing field as secular assembly uses. And that's really the beauty of it all.
Okay. And then your firm is, do I understand it right that you operate throughout the entire United States? You're not just working in Detroit. Is that correct?
That's correct. I mean, we just finished up a large case out in San Diego, California, for example, for a church called All People's Church. It's a very large church that's been in the city for a number of years. And they went through 7 years of site plan approval, which is just amazing. California is tough to develop, but
Yeah.
7 years. Planning Commission unanimously approved, City Council denied. We filed a lawsuit. A year later, we got it settled. They approved it, and now they paid our attorney fees. So that's what we do all throughout the country, from New York to California to and all throughout.
So when we have all different types of people who listen into the show, developers, builders, people that represent cities and engineers and so on. When you think of developers and some of the things that they should look out for when this comes into play, is there something that you generally, tell developers and builders and people like that, like, hey, be on the lookout for this, or this is something that you might see, and that kind of tells you that you might have this type of case that we could possibly help with?
Yeah. So with the developers or builder side, right now what we're focusing on really is two things. One is schools, and the other is redevelopment of closed churches. So on the schools side, if there's a school expansion or a new school, and it's a religious school, whether it's kindergarten, elementary, middle, high, or college, RLUIPA comes into play. And we've litigated those cases and have gone to planning commissions throughout the country on those matters. And it's not just, for a religious school, it's not just building a chapel, it's for everything religious school. So if the school needs a gymnasium, if the school needs a parking lot, things along those lines, we work with them. If they want to renovate and the property is historically designated, which is a big issue in California, for example, which precludes a lot of development work to occur there, or to stop development from occurring, parties will historically designate. A lot of Catholic missions and Catholic schools in the West Coast, for example, are facing that issue right now. RLUIPA comes into play for those. So that's kind of one part of it for developers, trying to work with these religious institutions on schools and things along those lines. On the other end is there's a lot of churches that are closing. So you've seen since about 2000, the Episcopal Church, which is really has tanked over time. They have a lot of property. They have very few people that attend. I think about 300,000 people a year go to those churches, which is just remarkably low. You have the Presbyterian Church USA that at one time, around 2000, had about 2.1 million. Now they're below a million. You have the United Methodist Church that has lost about a third of their churches through disaffiliations and closures. Catholic churches are consolidating, closing. There's a lot of empty space there. So you're trying to look at what can we do with this space. And a number of cities want to keep those buildings because they're landmarks within the city. They're part of the culture. They're part of who the city is. And also the local churches want to keep them as well to use for either religious spaces or for affordable housing. So we work with developers on those matters to see if that really if we can make it work economically. Affordable housing's tough all over. There's these places can be easily converted into housing. We've seen schools and that can that have been converted to apartments and whatnot. There was a hotel I stayed out in Denver that used to be an elementary school that is now a Hilton brand hotel. Things like that can occur, but you just have to make the money work. And so we work with developers on those grounds as well. So, redeveloping properties, closed church properties in schools, and then also redeveloping schools, whether it's new build or renovating, whether it's historic designation or whatever. That's a lot where we work with developers on those issues.
Gotcha. So when you're working on some of those projects, is it a matter of essentially working with the municipality on rezoning or getting a different designation of that particular property to be able to then redevelop it? Or what does that process generally look like?
It's usually not rezoning. It's usually site plan approval. A lot of the older buildings, for example, were built the way communities kind of developed, at least on the East Coast, and to degree on the West Coast, is the church, temple, mosque was built first, and then communities kind of built around them. So that's why you generally don't see parking lots in older neighborhoods. It was before cars. People walked to church or temple or mosque. And so they're generally, zoned as residential because when zoning first came out, they just designated that area as residential. So if you're going to convert them to residential uses, zoning's not really the issue. It's more along the issue of the use itself of how do we kind of fit like building code issues, and how do we fit occupancy loads, and how do we fit other things related to like multifamily uses within the former church building.
So going back to the Religious Land Use and Institutionalized Persons Act, I think I say that right there. If going back to that, why do you think a lot of people haven't heard of that? Like, I know coming into this for me, like I personally had not heard of it, and was just doing a little bit of research coming into this, but it doesn't seem like something that, at least in my world, hasn't come up much. Why do you think that is?
Well, because people haven't gone out and bought my book. I don't know. I don't know. I think there's a number of reasons for this. One is Congress enacted this law. There was a lot of litigation from about 2002 to about 2010 on these issues, and things have kind of settled down since then. And depending on what administration's in play, you'll see more of a focus on religious uses. So you had a lot during the Clinton era and a lot during the George W. Bush era. Obama came for those 8 years. The focus changed from RLUIPA to voting rights. And what I'm saying is RLUIPA also provides that the Department of Justice can intervene in cases or file statements of interest. And so there was lack of focus on that. Then you had Trump at first wasn't really focused on this too much. Biden didn't really have a focus on this at all. And then now Trump is very much, they do have a focus on it, where statement of interest, and they filed one lawsuit, which is very rare for the Department of Justice to do. So those cases, when the Department of Justice is involved, that's where you see media coverage on these issues. In other cases, you really don't, and it's kind of local coverage. Unless it's a peculiar case, like there's a case out of the East Coast right now in New Jersey where a city wants to condemn a church and remove it because the church wants to use it for a homeless shelter. The city said, we don't want that. We want to put pickleball courts there. And so that has grown, and it's generated a lot of interest. But unless there's at least what my theory is unless there's a federal lawsuit or federal intervention or statement of interest, you're not going to really see a lot of national coverage on these matters. Not a lot of developers know about this act. Not a lot of churches know about this act either. Pastors go to seminary to become pastors. They don't learn about land use. Volunteers are elders in churches or deacons or trustees, and they're based on their knowledge, and usually it's finance and personal growth and things like that. This isn't top of mind for people, so it's only top of mind when you apply for something and it gets denied, and then people start Googling to find out, oh, this act exists and this can help us.
Do most of these cases go to trial and everything, or are they usually settled outside of court?
Yeah, so most of the cases do not go to trial. I've had probably 11 trials in 20 years, which is not really a ton of RLUIPA cases that have gone to trial. Most are either settled or are dismissed on motion. Unfortunately, what happens a lot of times is somebody local within a church, synagogue, or mosque is an attorney, gets tapped on the shoulder and says, "Can you help us?" And they want to help, so they file the lawsuit. They do it on a pro bono basis, but they don't know all the intricacies of the case. So they don't know the case law. They don't know, the evolving standards and things like that. So they'll do the best they can, and then a motion to dismiss comes, or a motion for summary judgment comes, and the case gets dismissed. So about 80% of the cases are dismissed on these types of motions at the outset, which is unfortunate. We have, since we've been doing this for so long, we don't have that issue. But I just talked to somebody yesterday actually where their case was dismissed twice on a motion to dismiss, meaning that somebody wrote the pleadings of a lawsuit, and the court looks at that case and says, assuming everything here is true, there's no viable claim. And so that just tells me again, and unfortunately I tell the client, there's nothing really I can do for you if the case is dismissed by the court, because you had your one shot and it didn't work. So that's the unfortunate reality of it all. So.
Yeah, you mentioned your books, and that was something I had jotted down here as well. So you have 3 different books, is that right? Is it 3?
It's 3 books. The first one is the first 2. It's first and second edition of a book.
Okay.
Litigating religious land use cases, and that really kind of summarizes the case law up to I think 2016 or 18 or something like that on RLUIPA. The second one was a COVID book. It's another book on religious property disputes, and that covers both RLUIPA and the denominational departure cases.
Okay, nice. Well, I'll throw those links to your books in what's the best place for people to pick those up if they're interested in getting a copy?
Probably Amazon would be the best. I know the American Bar Association is the publisher, but I'm not entirely sure if they're still, stocked with them or not. I would think Amazon is probably the better choice.
Okay, I'll throw links to the books on Amazon on the show notes page to this episode. So those of you listening in, if you look in the description, you'll see a link to the show notes page, and then from there you can see a link to that and any other links we talk about here today. Do you have any sometimes with these types of these types of cases, it might be easier to understand it if we go through an example of a case? I know you talked about one a little bit in the beginning, but do you have a case that you could maybe dig into just a little bit to help kind of shed some light on it?
Sure. Let's talk about that All People's Church case that we just settled. Give you a little bit of insight on that one. So that's a case out of San Diego, and cases in California are subject to the California Environmental Quality Act, which is called CEQA. What happens there is you have to, if you're going to move dirt, you have to do what's called an environmental impact report and show that all of the potential negative effects of doing this development have been thought through and addressed. CEQA is kind of a notice provision of the law. So it requires a lot of community involvement. You have to go meet with the local planning group of a community. You have to meet with leaders in the community. You have to address all objections and things like that. And here in it, this community, this piece of property was originally zoned for residential homes. This community came out in force and said, we don't want residential homes there. So the builder said, fine, sold the property to the church. Then the community said, we don't want a church here. We want to have residential homes. That was their backup. And so we really went the effort of saying, okay, what is it that bothers you? Is it parking? Is it traffic? Is it noise? The kind of simple things you would kind of think about. And we were able to ameliorate and address a lot of those issues. But there are still a number of issues that no matter what we did, the local community was going to say no. So we had to go through that process of years and years and years of meetings, of planning review, submissions. We did all of that. We got to the planning commission. They unanimously approved. So the last step for a project like this in San Diego would be city council approval. And at that point in time, we get to the city council, and there was one city council member who lived within a couple miles of this project. He represented that district and very much came out in full force against the proposal at the meeting. So at the meeting, he came out with all sorts of reports and statements and things that we were never subject to or privy of that before then, never given any of that information. And he convinced his fellow city council members that this development shouldn't occur. And it was basically primarily based on traffic. And we had a traffic engineer that said it was fine. The city's own traffic engineer did a report and said it was fine. But this council member came up with his own version of traffic and said it was not. So council denied the use. We filed a lawsuit under claiming primarily two things. One was the substantial burden provision of RLUIPA. The other part is a violation of the First Amendment free exercise clause. What we did is we went through the history of this case, and we showed everywhere where we met all the criteria of CEQA and all the criteria of the San Diego zoning code, traffic codes, everything like that. We went through and established everything that was approved, and that how this city council member just kind of intentionally bombed this case, to make sure that it would not get approved, and that it wasn't grounded in facts. So we filed the lawsuit. We started doing some discovery. The city reached out to us and said, we got a problem here. Would you be interested in settling the case? And we entered into negotiations, and over a period of time, we're able to work with the city to really come up with a winnable situation for the city and for us. The winnable situation for us was getting the land use to build the building that we wanted. And we addressed one particular issue that the community came out against, which was they wanted to make sure that our gymnasium or family life center was not going to be used for a community basketball leagues. There's San Diego State University is right down the road from there. They didn't want this gym to be used 24/7. We never intended to use it that way. So we said, okay, we'll take the bleachers out and we'll agree not to put a locker room in. That way you couldn't have tournaments and you couldn't have things.
Was that a traffic thing that they were worried about, or was it competition with the San Diego State gyms that were available there or something?
I think so. And then other gyms in the area, there's just a lack of gyms in the area. So if you want gym space, you're going to have to reserve, and you might get like 3 to 4 o'clock in the morning, and that's it.
Right.
That's all available. So we agreed to take that out and address that issue. The city then approved it, and then we agreed not to pursue all the damages and attorney fees that we could have. We just went for attorney fees, and they agreed to pay those, and it worked out well. So that's one of those cases where it was really a case. The way we presented the case to the city and the information we got through discovery, there was really not a path forward that the city could viably take to prevail in this matter. And credit to the city attorney's office, really, to recognize that and to reach out to us and say, hey, let's see if we can work this together. Because there was a lot of lack of trust from my client's side of like, you told us for the last 6 or 7 years that we could have this. If we did all this, and then it was denied. So why should we trust you? So we had to do a lot of work I do a lot of work on my end with my client to say, yeah, they did breach our trust, but we think we can get this thing resolved. And if we can't, we'll litigate. So it worked out really well for us.
How does that work when you go through that process to try to settle? Is the city council still involved in that process? Or if they're the ones who voted against it the first time, do they still have to officially say yes to whatever is agreed upon?
They do, yeah.
Okay.
in California, not every state is like this, but in California, with CEQA, is the city council has to approve the project. So you can't approve a CEQA related project in California through a consent judgment. Most states like Texas, Michigan, Florida, you could negotiate a settlement with the city attorney, and then the case is over, and there would be no public hearing or anything along those lines. But California is unique that way, that it requires public hearing.
Gotcha. Um, I was going to ask too about the actual. Was that the? I'm trying to think here. You said 7 years. Is that right? Was this one 7 years it took from
7 years of site plan approval, yeah.
Okay, that's what I was thinking. That's a long
Brutal.
time. Yeah. Wow. Well, let's so I like to close out these episodes with what I call like a lightning round where I have 5 questions that I put in here. I wasn't 100% sure coming into this like what angle to take with the questions. They're usually just things that will help our listeners in, the type of work that they do using and leaning into your expertise. So if any of these don't really if they're not things that you necessarily work on or you don't really want to speak on them, all good. Just let me know. But
Okay.
so the first one is, what's the first thing you would advise a developer who is facing, and I'll say unofficially advise a developer who is facing a zoning issue with a municipality?
It's going to be much harder. It's going to be much longer, and it's going to be much more expensive than you can imagine.
All right.
That's always what I start with, because there's no quick fix to these things.
Yep. And I would imagine depending on the city or the state that you're in, and then the city as well, that's going to play a big role in how easy or how willing they might be to, come to the table and actually talk about fixing it.
Absolutely right. You're absolutely right.
All right, next one here. What's the most common zoning mistake you've seen developers make?
That they kind of wait too long to take action. Where you know, and I get it. The last thing you want to do is litigate, and litigation's hard. It's expensive and it's unpredictable. But there always comes a time in these cases where you just kind of know this isn't going to go anymore. So, there's a time where you have to push for, give me a decision. If it's I need a decision, you need a decision to go forward. You can't, in the most zoning cases, you need what's called finality. So you need to get that no. And then once you get the no, then you can go ahead and litigate. And at least that starts the clock in terms of, trying to come up with a reasonable settlement, because there's times politically it can't be it can't be resolved. But it can be a time when you get to litigation where the city can say, hey, it wasn't me. I tried my best, but the judge forced this down our hand. And that's what we have to do. So you kind of know as a developer, I've done everything I could do. And it doesn't make any more sense to delay this anymore. Make a decision, give us a no, we can go forward from here.
Do you see, and this isn't really one of the questions, but I'm just curious, do you see much retaliation from cities in situations like that where, a developer may not want to go that path because they're worried that their relationship with the city might turn sour or things like that? Do you see that very often?
I do, and I think that's why I get hired a lot, because I'm out of town. It's local attorneys are going to be coming back to the city for other clients, for development approvals. So they have to maintain those relationships with the city. I don't. I'm going to drop in. I'm going to work with local council. And I'm going to resolve the matter, and then I'm going to drop out after that point in time. But we do see that. It's a lot of it, unfortunately, is enforcement of the building code after their hand is forced to settle a case or give us the approval. I've seen where the building code's thick, but it also gives the building inspector a lot of discretion. So if the zoning and building department get together and say, put the screws to this guy, they're going to require them to put all metal doors in fire doors as opposed to wood doors, which is going to raise the cost tremendously. They're going to require sprinkler systems, even though it might not be required, on a space less than, 10,000 square foot. They might require, other things that are just not required, or calculate, parking spaces to the maximum degree so you can't get a big enough parking lot. I've seen that a lot. And we just go back to court and say, Judge, Judges don't like to get involved in health, safety, and welfare issues primarily, but if you can show a pattern of, hey, here they're only requiring 20 parking spaces for the same size church, there they're requiring 6,000 spaces. For us, that doesn't make any sense. The court's going to generally agree with us at that point.
All right, third one here. If a developer is denied a permit, what's the next step in your process? Like, at what point, I guess, does somebody reach out to you in this?
Usually the developer's attorney will reach out to me right before the hearing when they know they're going to get denied and say, what do we need to get into the record to make sure that we have a thorough enough record to either appeal this decision of the zoning board or to pursue litigation. So I generally get involved at that point in time. So somebody will reach out typically at that point. If they don't, what happens after the denial is I'll review the record, and then I'll see, is there a path forward, a litigation path forward? Zoning cases are tough. They're not cases that are generally not a lot of people pursue them successfully. So you have to have your elements in your record, the facts in the record, to have a good, viable case. And so making sure that the record's complete as much as it can be. So I may go back and submit something as like a motion for reconsideration with additional documents in the record, so we have a more complete record or something like that, just to make sure that we're good to go moving forward.
All right. Fourth one here. What's one zoning regulation that you wish developers better understood?
Developers understood probably parking. Calculating parking spaces is always seems to be the bane of somebody's existence. Where every city does it differently for whatever reason. Where some cities may say for an office you might need one spot for every 200 square foot. Others will calculate the hallway plus the office, adding another parking spot. Some will include the common areas, for parking and whatnot. If we could just have one standard on parking, and also, why is it one spot for 200 square foot? What if you bike to work or walk to work?
Right.
It shouldn't. I've never really, I couldn't really understand how these parking criteria come into play, and maybe that's why developers have a hard time with them as well. But that's the one thing.
Well, that's funny because parking has been a very hot topic on this podcast. We've had a lot of people talk about parking, asking those same questions. And we even, on one episode, we were trying to figure out, where did the parking requirements even come from? Like, where did they originate from? And we were having a hard time, and we never did get to the bottom of where they actually came from and why they are how they are. Because it was the same thing as what you were talking about. People bike to work. People, they don't all drive.
There's a professor at UCLA or USC. His name is Donald Shoup. He just passed away, who wrote a number of books on parking and parking theory. And he identifies the source, for these things. But quite frankly, the source is some guy saying, yeah, that makes sense.
Wonderful, right?
Yeah. Like for churches, it's one spot for every 6 feet of pew. I'm like, what? I mean, who has pews?
Yeah.
Seats, or whatever. So what are we supposed to do with that? So, yeah, exactly.
Yeah, crazy. All right, last one here. What's the most important document or resource for a developer to have when negotiating with a municipality, besides your books?
I think most important. Oh, that's a good question. I think it's a combination of the master plan and the zoning ordinance for the local community. Really knowing that community thoroughly before you create your plan, I think, is important. I think a lot of developers, have a plan that they've used successfully in one community and just want to use that and plop that into the next one, and it doesn't always work. I think you really do have to have a separate plan for each community before you move forward, and really understand what the community is looking for in a master planning concept and what they're looking for in their zoning concept as well. So those pre-meetings, I think, are super important with planning. I always recommend doing that. Always try to figure out, is there an amicable way forward? Last thing you want to do is litigate a case. And I know that sounds weird for a litigator to say that, but every time and money is so critical in development. If there's a way that we can move this thing forward, get the approval, it might not be everything you want, but 90% of what you want, I think it would still be a good plan. So I would say master plan and zoning ordinance.
All right. Well, we're at almost 35 minutes here, so probably a good spot to come to a close. Dan, what's the best way for people to connect with you and learn more about your company?
Well, you can find me particularly on LinkedIn, or you can look at our company. Our website is daltontomich.com. We've got a lot of resources. We've got books, ebooks. We've got a lot of blogs. We have videos on our YouTube channel. You can look at that as well. Or you can contact me directly. You can email me or give us a call here at the office. And all that information is on our website and LinkedIn. And happy to have a conversation with you.
Perfect. Well, as I said, I'll put all of that on the show notes page. So again, those of you listening in, look down in the description, click the link there, and you'll get access to all of the links that were just discussed here. Dan, thanks again for joining. Really appreciate digging into this topic, something I know zero about. So it was really educational for me, and I know everybody listening in is going to enjoy it as well.
Oh, I'm so glad. And thank you for the opportunity. It's been wonderful to meet you and have this opportunity to talk about RLUIPA and development.
Absolutely. All right, guys. Well, that is all for this episode. We'll come to a close, and we will talk to you all next week.